Hello, this is Matt on the Moon Lambo channel. Ladies and gentlemen, you have 1 day remaining to claim your Spark tokens if you've not yet done so. So this is going to be my final friendly reminder on the Moon Lambo channel that if you've procrastinated to this point, you must take action now. You are at the end of the road here if you want to claim your Spark tokens, right? And so I want to talk about that briefly, as well as cover a new document filed by the SEC in their case against Ripple today. More nonsense, complete and utter nonsense, rather pathetic attempt to respond to Ripple's most recent filing. And by the way, I've got comments from attorneys Jeremy Hogan and James Filan, both members of the XRP community, specifically on this topic, including how much Ripple is likely paying its lawyers just for the most recent legal filing, and the numbers are just like brain exploding. It's like levels. It's just like, wow, what in the ever-loving hell? I mean, Ripple must be spending a crazy amount of money. But before I go any further, I do want to be clear, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast who makes YouTube videos as a very fun hobby, but that's all that's going on here. And so your Spark token, you've got 1 day. Now here's the thing. So here's a tweet from Flare Networks. And this is from November 23rd, 2020. So we've known about this for a little bit, right? And here's what they wrote. Reminder. If you self-custody your XRP, then you have until June 11th, 2021 to make your Spark claim. So, technically, they didn't clarify. Sometimes when people have a deadline, that means you have to do it before that. I don't know if you technically have all of June 10th and all of June 11th to make the claim, but even if you have all through June 11th, which probably is the case, they didn't cite what time zone they're looking for, and I couldn't find it on their website. Maybe they cited it and I just didn't see it. And so consider this. When the Spark snapshot date occurred on December, it actually occurred on 2 different days depending on what time zone you're in. It occurred on December 11th and December 12th. Now, to be clear, only 1 snapshot was taken. I'm just saying, depending on where you are on the planet, it was either December 11th or December 12th. So I don't know for sure when the deadline is for this. So if you do want to claim your free Spark tokens, you better act soon. And I'll tell you what, I'll go ahead and provide a link to a video that helped me when I claimed my Spark tokens about a week ago. Maybe it was a little less than a week ago. But it's from an XRP YouTuber called XRP Dev, who's been out making videos for about 2 months now. And so it's a fantastic video. I'll be sure to link it below. It is a little bit quiet, so you're going to have to crank the volume up, but I found it to be very helpful. And so just want to be clear here, like, the Spark token could be worth a fortune in the future, which is why there's no way I was going to pass this. Mind you, as I record the video, the Spark token IOU is worth $1.48 according to Live Coin Watch. So we'll see where it goes. And again, the blockchain, it's not live. And so what is being traded right now on BitTrue and Poloniex, which are the only Spark token markets that are open now, they're just representations of what will be available in the future, because the Spark token has not yet been released into the wild yet. When will it be released? Well, take a look at this. This comes from the Flare Network's Twitter account. The Spark token distribution will start when the Flare Network goes live. The team is working to make this happen safely as soon as possible. It is dependent on finishing security testing. We expect this at the end of June, plus or minus 2 to 4 weeks. So, and this is the most recent update. This is from April 16th this year. This is the most recent update that I could find. If you have anything else, please drop that information in the comment section below with a source. But this is it. So it's coming very soon, and I, for one, am very much so looking forward to this. And now into the next topic here. I made a video just the other day about just more nonsense from the SEC. Because here's the thing. The SEC and Ripple, they've agreed to a schedule for the discovery process. The SEC, on top of the fact that they agreed to that. They've had, leading up to this, they've had years to prepare a case against Ripple. And then when they filed it at the end of the year, one would have thought that if they filed it, they'd done all the homework they needed to do. But now it doesn't so much seem that's the case, because they are requesting a 60-day extension. And so I made a video where I broke that down, and I'm not going to rehash all of that in this video, but I did want to make sure you were aware of it because it's relevant to the most recent legal filing today. And so Jeremy Hogan, upon reviewing this information, he wrote the following. The best part of this opposition by Ripple is when it points out that many of the delays the SEC complains of were caused by the SEC itself. For example, failing to turn over documents related to Bitcoin/Ethereum's status as a security after being told twice by the judge. Legal judo, right? And it's funny because I actually pointed out the exact same thing in my video that I put out just the other day. Like, you caused this. Like, think about all the extra nonsense arguments that you made up that, frankly, I don't believe the SEC believes half of what they're even talking about here. But think about all the claims they've made, that which I've been covering on this channel. Every day they pop up, I'm reporting on. Think of all this stuff, and I break it down on this channel. It's nonsense. It's incoherent. And their behavior's unethical. It's so illogical, though. I don't think they believe any of this nonsense, or almost none of it. And so then they have the audacity to request an extra 60 days when they've been slowing down the process for Ripple and for themselves. What in the ever-loving hell is going on there? And so this gets expensive, too. And so check this out. I think you'll find this little tidbit interesting. Somebody responded to Jeremy and wrote, Jeremy, I am curious as to how long these letters take to draft and the level of reviews it must pass through at the firm. That's an excellent question. And I believe, I could be misspeaking, but I think that document, which I just covered yesterday, I believe it was 8 pages. 8 pages, right? Jeremy Hogan responded. Attorney Jeremy Hogan, member of the XRP community, wrote the following. This is, like, mind-blowing to me, but he wrote, I would estimate this letter is about 10 to 20 hours of research time by a young lawyer and another 20 to 30 hours by partners. Associates brief the case authority and partners draft the letter and consult with client for modifications. This is top-level work and billed about $20,000. $20,000. My friends, keep in mind, that's one letter. That is one letter. And previously, and I don't know exactly what the numbers are, and I can't remember where we got this information from, but it's just off the top of my head. But I remember it being estimated that Ripple spent, and this was months ago, mind you, to that point, something like $3 million on this. I believe that's what it was. And I'm sorry, I wish I could remember exactly where I got that from, because I like to cite, if I make a statement like that, it's nice to have a source. But I don't know, take my word or don't. I believe that's what it was. Though. Either way, I remember it being like millions of dollars. That's insane. And so then you think, well, how does that add up? And then you see like, oh, this is one letter. There's letters every day. Just like, doesn't it seem like that? Like just about every single freaking day. And so here's the most recent thing in response to Ripple's, like I said, 8-page filing, saying, no, we do not, we are not okay with this 60-day extension. And then this is the SEC's response to that response, to Ripple's response, effectively. It gets ridiculous. And this comes from attorney James Filan, and he did share his opinion, which I'm going to share with you in just a moment, but let me run through part of this real quick here. He did cite here, though, the SEC has filed a one-page response to Ripple's SIR reply to the SEC's motion to strike Ripple's fair notice affirmative defense. And so I had to look up SIR reply the other day because I don't have a legal background. I was like, what the hell is a SIR reply? As far as I know, it's only used by lawyer people and lawyer types. And so I'm guessing that almost 100% of you also were not aware of what SIR reply is. But basically, the way that I dumb it down anyways, basically it's like additional reply. Just take it like that. I don't know. That's as far as I'm concerned, that's what it means. I did Google it. I have the sum of all human knowledge at my fingertips, my little Moon Lambo fingertips with the Googles. And so I looked it up, and that's what it said. Anyway, so this is what was filed today, June 9th, 2021. Dear Judge Torres, Plaintiff Securities and Exchange Commission respectfully responds to defendant Ripple Labs' SIR reply to the SEC's motion to strike Ripple's fourth affirmative defense. The SIR reply argues in part that the SEC's 74 enforcement actions in the digital asset space before it filed this lawsuit were insufficient to provide Ripple fair notice that its unregistered sales of XRP could be illegal, such that due process is not satisfied. Okay, and so for those of you that missed my video the other day on this, out of the 75 that have been filed, and the 75th would be Ripple, I believe, I think the numbers were something like, could be, I think it's 37 of the cases that were filed had nothing to do with the sale of a cryptocurrency. There are companies that were selling unregistered securities in the form of stock. Nothing. So I don't know how the hell that informs. How is that supposed to inform Ripple that a digital asset that they did not create that they're selling, that's a violation? Now that's a tremendous leap. What in the ever-living hell? I know. It doesn't make a damn bit of sense. The Chewbacca defense, alive and well. And so there was that, and then the other 37, they were all ICOs. All of them were ICOs. And so XRP was created before Ripple existed. There was no ICO. And I just don't see, when you're talking about the distribution of XRP getting out into the wild, I just don't see how you can conflate the two. It just doesn't make any damn sense. But here's what the SEC wrote. This argument is based on an incorrect characterization of the fair notice defense. So the fair notice defense, it's this idea that Ripple, there's no way that they could have known that what they were doing was illegal because there wasn't sufficient regulatory clarity. And the SEC allowed them to operate in broad daylight for the better part of a decade. They went after all sorts of other ICOs that popped up in 2017, quickly squashed them, but they knew the people at Ripple. Like they were having at some points weekly conversations with people at Ripple, and there was not notification that what they were doing was wrong. They were just supposed to magically know. And so this idea that they didn't have fair notice is actually a very strong defense for Ripple, because if it's found by the court that Ripple did not have actual fair notice, this case is over. And that's not conjecture just on my part. That's not speculation. That's how the law works. If Ripple was not provided fair notice, they cannot be at fault. Case over. Like boom, slam dunk. That's what would happen. And so then the SEC writes here, Ripple's argument boils down to this. Because none of the SEC's prior digital asset cases involved the exact same identical facts as this case, Ripple lacked sufficient fair notice such that it cannot be liable for violating Section 5 strict liability provisions. Okay, I'm going to pause there. That is not true. That is not what they said, but there is a very key piece that is different. It's not the only one, but it's one very key piece, which is what I cited, which is that Ripple didn't have an ICO. And so the other companies, the other 37 that the SEC went after that did have an ICO, like there was no existing blockchain. They were literally taking money from investors to use it to fund the creation of their blockchain, their cryptocurrency. That's what it was for. That's a core difference, an absolute core difference, especially since the SEC had been verbally articulating up to that point that they were going after ICOs specifically. Well, Ripple didn't have one of those. So how the hell is that supposed to be fair notice? And so they're pretending oh my gosh, look, Ripple, there have to be identical facts in this case. No, this is not what is being stated. There's a very core piece though that is missing, and the SEC's pretending like it's a big deal. It would be just as stupid as if they're like, hey, there's a law that says it's illegal to eat bologna sandwiches, and then like you conflate the two, like they relate to one another. You know, if there's a law that says you cannot eat bologna sandwiches, and then Ripple sells XRP to key strategic partners, you can't say that they had fair notice. Okay? It's not a bologna sandwich. Damn it. Freaking asshats. And so anyway, then the SEC writes, but fair notice does not require such exact factual correspondence, and Ripple cites no case that suggests anything to the contrary. What case do you want them to cite? Like the case of the bologna sandwich versus Ripple selling. Like, there is no such thing. Like, there is no such thing. What do you want them to cite here? It's absurd on its face. And I think that this attorney knows that this is a rather poor argument here. And so this is what we're working with here. This is exactly what we're working with. And there's no new information. In fact, so James Filan, upon reading that, wrote 4 words. It's a pathetic response. I'm going to heart that one right now. There we go. Hearted that all up on the Twitters. And then somebody named Bill had a question. Wrote, James, do they actually oppose the request by Ripple for permission to file the SIR reply? They seem to just respond to the SIR reply and assume permission was granted, which actually is not what was going on, and James cleared this up. Or they weren't asking for a permission. Ripple was actually filing in response. So anyway, here's what James Filan wrote. The SEC did not oppose Ripple filing a SIR reply, but reserved the right to respond to it if they felt it was necessary. So this is a response to the actual SIR reply, not the motion to file one. And then he wrote in a separate tweet, this is attorney James Filan again, it was like they ran out of steam and just felt as if they had to say something. It was half-hearted and really added nothing that hadn't already been said. So there you go. SEC full of a bunch of assets that refuse to use logic. Maybe they simply don't know how. That's not really what it is, though. I just think that they're unethical people, because there's no way that you could be so stupid to believe so many of these arguments that the SEC is making. I don't think they're that stupid. I think they're that bad. That's what I think, personally. But I will go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.